Good morning, everybody. Let's go on the record. 19 CF 7518. I have Counsel of State Defense, Mr. Quiles present. Good morning, everybody. I wanted to have a status court date ahead of next week to go over some preliminary issues regarding jury instructions, things of that nature. That way we can get started rather quickly on Monday with the jury. I told the jury 10 o'clock. Does that time work for everybody? I kind of set it off the cuff, not talking to counsel beforehand. I just wanted to avoid some rush hour traffic for them, and then that gave us some buffer time if we needed something Monday morning over the weekend. Before I begin, is there anything else that we need to handle from any party's perspective before we go into some of the instructions, first from the state's perspective?
Very briefly, Your Honor, we had discussed with family that we are, for the moment, we would have two. That's kind of what was expected. There's a rule to that, but we try to talk to the family last night. We anticipated two of those. It puts the state in a tough predicament. We didn't ask them to write those before verdict, so unfortunately we can't hand them to the defense. This morning we have asked the family to get them to us by Sunday. They've agreed to do that. As soon as we get them via email or otherwise, we will cancel those. It'll also have identifying who the family elects to speak. We want obviously second. We left them with that decision last night. Other than that, that's all the state has. We just want to make sure it's clear we will get the facts. Defense, as soon as we get them, we give them an opportunity to review and object, and we get the section that they're in. Otherwise, other than going through court wants to, they nothing.
Does the state plan on reviewing the statements prior to getting them to the defense as well so the state themselves can look at it, make sure nothing objection from their perspective, and in that way not watering it down, but making sure it complies with the statute?
Yes, sir. We're very aware that this is more about her IS, the unborn child, and IS is we will read them with that eye. If we think there's anything beyond what we think the purpose of this particular phase, we'll obviously strike those statements ourselves. But if there's anything left that the defense objects to, we'd like to get it to Sunday. So they can, yes, sir, we recognize that if we get to a Spencer hearing down the road, there may be additional comments they want to make, but we've asked them to write an impact with respect to the impact of this child IS to the community. We'll, of course, review those to make sure that.
Okay. Anything from the defense perspective before we go any further?
Sure, Judge. I know I reviewed the order back before we started the trial from Judge Carbula as to specifically this issue, and I remember there being some details of exactly what procedure we needed to follow. So I will review that again to make sure. And if I'm not mistaken, I believe it even said it has to be read word for word, and that the family needs to be advised that they can't deviate from that and those type of things. So I would just request that we all review that beforehand to make sure that we're in compliance with that order.
We concur, Your Honor. We told whoever is going to be there, they has to be sworn, prepared in advance. Whatever the defense agrees to will have the words. We also have talked to them already about the very, very best they can maintaining their motion. Said that to them repeatedly. We have a victim advocate that sits with the trial and has already been telling them to go out first in the trial. The court probably would test and the record would show. Didn't have any of that during the trial, so we don't at the penalty phase, particularly during the testimony. We will tell them, of course, if they begin to break down what we usually advise them, and I would certainly do that in this proceeding, is just try to ask them to hold that in. But I try to signal to the witnesses if they feel like they're going to get a motion to look at the court, not us, and saying they have a moment, Your Honor, and that would be an indication they're about to have some emotion and they find control. That one we would ask the court for that, or even any of that. So we always do that. We will do that in this case. And of course, comply with counsel pointed out.
So you're
And
saying that would be the code word. When they look at me and say, may I have a moment, that would be the code word to say, I need to excuse the jury.
Yes,
Okay.
you're asking for it. They do that.
The defense agrees with that procedure, and we will instruct our witnesses in the same manner to do the same. I mean, I think it's emotional for both sides, considering where we are. And so that's obviously, of course, we're not opposed to that at all.
So the order Judge Corbula entered, I pulled it up while we were going over just to talk about it. It obviously said the state would work with the victims regarding preparing the statements, knowing what the statute allows and does not allow. You know, obviously not about the defendant, not about the crime, but about the victim and their uniqueness. And that you'll explain what they can and cannot say pursuant to law, as you've already explained. Once they're finished, I'm just going through the order now, just so since we're talking about it. Once it's finished and reviewed by the state to ensure that the statement is admissible, so the state will have an obligation to review it to make sure it complies with the statute.
Yes, sir.
It can then be provided to the defense for review, including the defendant, of course. After review, the defendant can consult with the state regarding any objections to the statements. All agreed upon redaction shall be made, and a clean copy of that statement can be prepared. So anything that's objectionable or objected to and the parties agree can be taken out, and a clean copy is prepared. And then it says, prior to trial, the state shall provide a final draft to the court, and the court will hold a hearing to hear any and rule upon any objections. So you can do that Monday morning. So you guys talk Sunday night, early Monday morning, send me a clean a copy of what the state believes they can present, if there's any objection, maybe cross through it in the line item in the document. Track through things, the phrase for a Word document, you track through it or something, and then track changes. And then send it to me, then we can take a look at that early Monday morning. But I assume you guys will work through most of those issues to assure there's no appellate issue on that.
Yes, sir. If they do object, we will most certainly, without knowing what they are at the moment, we generally agree. We know this is something not argues a factor. If there's an objection, we will look at that with certain cautious eye. Likely. If there is any disagreement, Your Honor, I believe that.
And then it also says how to handle any objections. If we get to that point, hopefully we don't. It also says that the state will instruct the witnesses to read only the statement verbatim, not to go off script, to offer any opinion or characterization about the crime, the defendant, or the potential penalties. And that's essentially it. And that, just so you guys know, that order by Judge Quiles was entered on July 14 of 22. It's on docket line D322. If you guys want to take an extra look at it. Anything else from the defense perspective?
No, Your Honor. We did speak to our client just briefly about he's entitled to a PSI. We've not completed that conversation. We just began talking to him about that this morning. So we do need to address that a little further to make sure that he is going to waive that or not. Is there anything else that we? I would have,
depending on the jury's recommendation, I would have intended to order PSI.
Correct.
Next week, depending on what the jury does.
Okay.
But I'll have to look at the statute to see whether it's even waivable. I don't know, given the penalties.
Understood, Judge.
Okay, so I have in front of me, I printed it out this morning, the defense's pleadings filed on 8/10 of 23 regarding a list of non-statutory mitigators and a list of catch-all mitigators. I wanted to talk about this to make sure I incorporated everything the parties want me to incorporate in the jury instructions. I did email out this morning the preliminary instructions that I read to the jury. The preliminary instructions, of course, do include the aggravators alleged by the state. what I want to do is first talk about the aggravators alleged by the state, since that's what's included in the preliminary instructions, and then we'll kind of work our way through it that way.
Yes, sir. Request to remain seated.
Yes, you guys remain seated, be comfortable as best as you guys wish. So state your notice of intent with the aggravators was filed back on August 8 of 2019. It was filed by Ms. French and included 7 aggravators. Are you proceeding on all, are you dropping any of those aggravators, or are you proceeding on all 7?
Your Honor, yes, as we sit here today, Judge, if you want to go through one by one, that's fine.
I probably will. I was asking the
Yes, sir.
first catch-all question.
Well, yes, but I would note the court has 1 through 9 on the preliminary that you sent this morning.
Yeah, that's not an accurate statement. That was me putting everything out there the best I could, and then I would narrow it down based on conversations during court today.
Yes, sir. So the ones we have, obviously, we have always intended on proceeding on. However, the state is intending on looking at the HAC aggravator case law more this weekend. As we sit here at the moment, we do intend meeting, recognizing if we abandon it, obviously that would ignore to the defendant's benefit, being no prejudice to him. So with respect to what we have on the notice at this time, yes, sir. The only potential announcement that could change would be as to H, which is the 4th one listed on the notice, the especially heinous atrocious cruel aggravating factor. Some case law we believe supports our position, but we just ask the court for the weekend to go deeper into that. But otherwise, yes, sir.
Okay, let's go aggravator by aggravator. Then the first one being previously convicted of another capital felony or of a felony involving the use or threat of violence to the person. The standard jury instructions talk about previously or contemporaneously convicted. In this case, I think we only have a contemporaneous conviction. What conviction are you moving forward on?
It's this one, Your Honor. Count 3 is the one that first aggravating factor is relying on. I would note for the court that contemporaneous convictions involving other crimes committed on a homicide victim cannot be used to prove this aggravating circumstances, this aggravating factor. However, and that's Lamb v. State, 532 Southern 2nd, 1501, Supreme Court case here in Florida from 1988. However, if the felony was not contemporaneous, although the same victim was involved, the aggravating factor should apply. And that's why we're relying on count 3 in that site. Ogle v. State, BOGLE, 655 Southern 2nd, 1103, another Florida Supreme Court case out of 1995. So in essence, Your Honor, yes, so long as it can be the same victim. So, and obviously, we've never, in our closing argument, the evidence, there's no proof whatsoever factually that the sexual battery was occurring within the 1920 time frame of December. We've articulated very detailed manner that the one date that we know that we allege and that the jury's now found with respect to the sexual battery was July 7, 2008. Furthermore, Judge, we'd also cite to Buzia v. State, BUZIA 926, Southern 2nd, 1203, a Florida Supreme Court case from 2006. And that case stands for the proposition that a jury finding of guilt before adjudication is proposition. So our position with respect to count 3 is exactly where it sits now. This court doesn't adjudicate yet. That still can't qualify as this prior felony. So our position is, as we sit here, we are proceeding on that aggravating factor based on the case law, citing the fact that acts that we're alleging have occurred or earlier in this relationship. The jury's heard all these facts. There's no evidence whatsoever that any sex bat happened at the time of the murder. So our position is count 3 is the aggravating factor of a felony involving the use of threat of violence to the person. Obviously,
Here's my question, State. The standard instructions don't define, I mean, obviously, we know what a capital felony is. Jury instructions aren't defining the felonies involving the use or threat of violence to another person. Obviously, the facts of an underlying sexual battery could be a wide range of underlying facts.
Yes, sir.
In this case, based on the evidence we heard, I'm not sure there was any use or threat of violence that came out of trial. That's my concern at this point, and I don't know how the case law talks about that.
Yes, sir. I will tell the court Hess v. State, 794, Southern 2nd, 1249, Florida Supreme Court case out of 2001. Quite frankly, stands directly what the court is inquiring about. Sexual activity with a child is a crime of violence. Now, it goes on to state, lewd and lascivious assault may be a crime of violence depending on the facts. Obviously, in this case, that lesser is sitting there. The court will remember yesterday we actually requested and agreed to strike that. So leaving the jury with that one option, count 3 was intentional. Not only the date purposes that we put on the record initially, but also to make it clear that when they made their verdict with respect to count 3, the sexual battery, it references sexual activity with a child. There's certainly no question factually that there was sexual activity with this child. In that case, Hess v. State stands for the proposition that any sexual activity with a child is a crime of violence.
So the jury instruction would read as follows: Johnathan Quiles was contemporaneously convicted of a felony involving the use or threat
of violence to the person. The state will keep its comments to sexual activity with a child as a crime of violence. We're not going to, the state know it would draw an objection if we were to say something that's not in evidence, like certainly he held her down or used a weapon. We would never make any arguments like that in penalty phase. We would stick with the base proposition that sexual activity with a child is a crime of violence. He has authority over her. Things along that nature. We would never going to say that sexual battery was used as an instrument, a weapon, he held her down, or anything of that nature. We're going to stay with what the case law permits, which is any type of sexual activity with a child.
So then the way the jury instruction would read is as follows: Johnathan Quiles was contemporaneously convicted of a felony involving the use or threat of violence to another person. The next paragraph or sentence would read underneath it is: the crime of sexual battery is a felony involving the use or threat of violence to another person.
I would say would be
Sense? I mean, this is not going to bind you. If you want to, we can always re-engage it on Monday. Just giving you the platform to say anything you need to for the record.
I was researching this issue, and I have not found any case law contradictory to what Mr. Skinner said as of yet.
Okay, then the second aggravator, the capital felony was committed while the defendant was engaged in or was an accomplice in the commission of or an attempt to commit or flight after committing or attempted to commit enumerated felony and or felonies.
the only one we're alleging there, Your Honor, if you put an enumerated felony, certain sexual battery. As to that aggravator, we are arguing that the ongoing relationship in finding count 3 was already found by them sexual battery. We're not saying act. We're saying that's the reason you see in the indictment we have to file on or between dates
You're saying the way it should read is, because there's a lot of commas in that aggravator that if you don't read it carefully can be very confusing. There was no attempt here, so or accomplice. So the way it should read is as follows: the capital felony was committed while the defendant was engaged
In
flight after committing sexual battery.
If the defense wants any or all of that language, the state will not object, just so our record's clear. If the court's limiting some of the language that's in the standard instruction, we defer to the defense. It's up to the state to explain that this murder was committed while the defendant was engaged in. Never going to argue accomplice, and never going to argue intent, or flight after committing or sexual battery, even the word illegally doesn't. We could argue he was in a form of a flight, and he was trying to get away from this particular situation he found himself in. So yes, I'm not opposed to the court being in flight. Certainly, he was engaged in sexual battery or flight after committing sexual battery. The state agrees with all of that. At the request, if the defense objects and wants all of that language in, we don't oppose. If the defense agrees to the accomplice or the intent language, we don't oppose that either. We want the record clear that whatever they want with respect to that back instruction.
Mr. Davis, Ms. Michelle.
And Judge, you did say we could sit. And just to be clear, in reading this, I interpreted it as three separate options: engaged as one, and accomplish in the commission of flight after committing as one, or attempting to commit as the third. And I just want to make clear,
Can
obviously,
you repeat that again?
the three versions of that would be engaged and accomplish in the commission of flight after committing, or attempting to commit. Those are the three options. And so obviously I don't disagree that they might argue about being engaged in, but I don't think the other two are relevant to anything that we heard in any evidence during the trial. I don't think there's anything that he was an accomplice in the commission of flight after committing something, or that he was attempting to commit at the time either. So if anything, I think maybe just to make it clear and to limit the amount of confusion would be to eliminate the other two after engaged.
Your Honor, for the record, the state's not opposed to that. There was talk of them running away. Now, we argued and made it clear that was a ruse to get her to school. So we do concur that we never thought the defendant, nor is there evidence that he truly was intending on fleeing from the sexual battery. However, it was a ruse. I will tell the court our argument has been largely, it will be based on engaged in. So if the defense does not want that language of accomplice or flight, I'm not going to object. We realize how serious these aggravating factors are. So if they don't want that language, we're not going to stand in the way.
And I just to make it maybe a little bit clearer, I don't think those are two separate things. I think it says that accomplish in the commission of flight after committing as one option, not he was an accomplice or he was in flight. So maybe that's just my interpretation of it, but if you can look at it and let me know if I'm reading that wrong.
The way I would read it, given all the commas, is that I'm going to get rid of the accomplice or attempt language. I'm going to read it as if that verbiage was not included in the aggravating factor, because we all agree that's not what we're talking about.
State agrees.
The capital felony was committed while the defendant was engaged in the commission of or flight after committing sexual battery.
The state does not oppose that. The state would concur with the court.
The state's saying they're not even going to argue flight.
No, I understand, Judge.
And so the question becomes down to, do you want me to read it as I just phrased it, getting rid of the accomplice and attempt language, and just probably engage in or flight, or just mention engage?
Judge, our preference would be to just have it as engaged if there's no true evidence of the flight. I know that there was mention of running away together and
Correct.
things along those lines, but not in that sense of what this, this instruction is for. But again,
So-
defer to the court on that.
Let
But
me ask you this question. Are you arguing flight?
The only time, if the court believes it, what we would intend to say is, the state of Florida never believed that it was flee. His purpose was to kill, to avoid having to, it was a ruse to get her from the school. So we agree there's not evidence that we would point to that he truly was going to. In that light, there was testimony that the argument could be made, but even so, if the defense is objecting to it, we are not going to, we will not ask the court to give that instruction logic and objection.
And we would, Judge. We would, our preference would be to just leave it as engaged.
For purposes of the state's record, make a record of our argument. That's why the indictment has all those dates it covers, all the way up and through December 20, 2018. Our position is, really, we could only pinpoint one date, while there were multiple ongoing, as the indictment alleged, of several acts of sexual battery. We charged one count on it between those days. So that's why we have it covering all the way through the homicide. Not to mention the facts bore that out, but also the jury's finding bore that out. But now, with respect to this aggravator that's in the commission up, based on even just the dates we have charged. So we concur with that.
Okay, so the way I have it written down is, you guys will get a hard copy of this as well to review over the weekend. We can talk about it Monday morning if you think about it over the weekend more. The first degree murder was committed while Johnathan Quiles was engaged in the commission. Hold on a second. I'm sorry. What each reading makes no sense. The first degree murder was committed while Johnathan Quiles was engaged in the commission of after committing sexual battery.
I would just say, Your Honor, the first degree murder was committed while the defendant was engaged in sexual battery.
Engaged in after committing. So the first degree murder was committed while Johnathan Quiles was engaged in.
Engaged in or during the course of.
That's not what this says. They're not during the course of. That language is not in the aggravator.
What I was going to suggest, Judge, is the first degree murder was committed while Johnathan Quiles was engaged in or after committing.
That's not what it says. We're adding language to the aggravator. I'm not doing that.
Okay.
I agree with the court. Does the court or the defense disagree with this? First degree murder was committed when the defendant was engaged in sexual battery. It's up to the state to argue that's then they're finding.
No, because it does not say that. It says after committing the felony. You're saying while engaged in sexual battery, as in it's currently occurring. That's not what the language says. The language And just the way it's phrased is confusing. Because of the commas, if you get rid of the commas in the accomplice and the attempt language, it does, or in the flight language, it does not make sense.
But is the court reading it like the flight after committing? Meaning that's
That's what it says. It says, or flight after committing.
and the state's not disagreeing. That's why I'm saying if we're eliminating flight at the defense requests, and with their objections, then the only thing left would be the first degree felony was committed when the defendant was engaged in sexual battery. Now we concur, the state of Florida concurs, it won't argue if sexual batteries happened on December 19th or 20th. All we're going to point out to the jury is this was an ongoing relationship with sexual battery.
I got it.
Okay.
Let me read. The first degree murder was committed while Johnathan Quiles was engaged in the commission of It still doesn't make any sense. I'm sorry. If I got rid of all the language, but the engage and the flight language, it reads as follows. First degree murder was committed while Johnathan Quiles was engaged in the commission of or flight after committing sexual battery.
And I don't disagree with that, Your Honor, especially I pulled up the current statute as of today, and I'll read it for the record.
Yeah, I have it in front of me.
Yes, sir. And it does reflect exactly what the court just read. That is the language.
It just doesn't make any sense. Engage in the commission of or flight after committing sexual battery. So basically it's saying that he was engaged in the commission, the murder occurred while he was engaged in the commission of sexual battery, or of flight after committing the sexual battery. We can all agree the first degree murder did not occur while he was engaged in sexual battery.
Yes.
So that's not, so that language we're talking about is not even applicable.
But it is, Your Honor, legally, because I think we're saying two different things. Factually, the state will not argue that there was a sexual battery incident occurring on the 19th. However, their finding was the dates and the indictment.
I got it. I think I have a better understanding. Give me a second. I think I have the language down. The first degree murder was committed while Johnathan Quiles was engaged after committing or attempting to commit sexual battery.
Well, the one thing we would request then would be the commission of, not during, but was engaged or in the commission of sexual battery.
It doesn't say or.
What it does, if we strike was an accomplice.
The or is in the commas. The or goes to the accomplice. You're either engaged in or an accomplice.
Then we would ask
In
the
the
court
commission.
to was engaged in the commission of, not during.
And that makes no sense. Was engaged in the commission of after committing or attempting to commit sexual battery?
Reading directly from the aggravating factor of the statute, that's what it says.
Tell me how that sentence makes sense.
Well, makes sense because
Yeah, how about
dates
this?
in the indictment.
Let's put a pin in this one. Let's come back.
Yes, sir.
It's now 11:34. You have a 12 o'clock meeting that you're not going to make at this point. The next aggravator that's alleged is the murder was committed for the purpose of avoiding or preventing lawful arrest or effecting escape from custody.
Yes, sir.
So the language I have is, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody.
Yes, sir. We're obviously arguing for preventing a lawful arrest because example number 1, statement on the wire, that kid is mine, I'm sitting right here in jail with the officer. We'll be arguing he was avoiding a lawful arrest on the sexual matter. It's very straightforward.
Are you in agreement with getting rid of the or effecting an escape from custody language?
I'm not, again, I'll say this, the state's not opposed to that so long as the defense agrees.
That's fine, Judge.
Okay. So then the language is going to read, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest.
State agrees.
Defense agrees.
Number 4 is the standard HAC language. You said you reviewed that over the weekend.
Yes, sir. We agree with the language the court has in its instruction. All of it.
And so one thing I'm going to have to tell the jury too is some of these aggravator factors go to both counts 1 and 2. Some just go to counts 1. Some go to just count 2. We need to figure out which ones I'm telling them go to both, which ones go to a particular count. And an example of that will be victim under the age of 12. That doesn't go to count 1, obviously.
Only count 2.
So that's something we need to tell the jury. The next one is CCP. That's standard language. There's nothing particular about this case in it.
State agrees to all the language the court has proposed.
Defense agrees.
And then the next one is the unborn child of IS was a person less than 12 years of age.
State agrees.
Agreed.
And then the next one is only, let me ask this question, is this the last aggravated factor to both counts or just one?
Your Honor, it's to 1 because we really have a hard time arguing with the unborn child. Custodial authority or uncle.
Okay.
So well, you should be worried about the care of his daughter while unborn. We recognize that stretch of an argument. But ideally, when that child, when IS was at his home, he is certainly the custodial authority over her. He taught her to drive, made her dinners. She stayed there a lot overnight. We heard all that testimony. He is his uncle by marriage. We heard also from Naomi that laid up a lot and or gone a lot, leaving him alone. So those certainly is to count 1. Judge, if I could just do a little research on that with regard to the unborn child, I don't think I've ever seen that issue on a custodial. Aggravating factor with an unborn child. I don't believe there's any case law out there. I've never seen it, but I'm calling. I would just ask to let us have the weekend. Whether we ask for that.
Do we agree that, so the way I have them listed in the jury instructions is 1 through 7? Yes, ma'am.
Right, and we would just request to remove due to advanced age or disability, since we
State agrees.
just have it read, IS was particularly vulnerable because Johnathan Quiles.
Okay, fair enough. So it would read as follows: IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over IS.
Correct.
Okay, so can we agree that 1 through 5 go towards both counts 1 and 2? And then count 6 is only to count 1, or excuse me, count 6 is only to count 2. Excuse me.
You agree, Ken, the 6th one is only for count.
And then the 7th one is what you want to research over the weekend.
Yes, sir.
Yeah, we need to come up with some language as to how I tell the jury, because the verdict form is going to be different then. Which ones, I could say these are all the aggravators being alleged by the state, and then the verdict form is going to tell them which ones they need to find. But I think it's a good idea to tell the jury this is what applies to each count, so they're aware of it on the front end. And it could be as simple as, I tell the jury at the very beginning, all these aggravators apply to both counts 1 and 2 unless told otherwise. And then when I get to number 6, I says, this one applies to count 2 only, boom, and then we'll determine about count 7 on Monday morning.
Yes, sir, and I think that's common sense. You can think that they're certainly going to see the 6th one and realize that OPSI does not apply. State agrees with the proposed language by the court in that regard.
That's fine with defense.
Okay. And I'll email this out when I'm done. That way you guys can see what I'm doing on the computer. Then the rest of the instructions are standard.
Yes, sir. The state has read every word of this, and we have no objections to the rest of it.
Okay, we'll get back to the one we're debating about here in a moment. Let's move on to, so at this point, the ballgame, the jury doesn't know anything, is not defined the mitigating circumstances. That comes in the latter jury instructions. I've gone over the pleadings filed by the defense. It looks like the only statutory one this defense is relying upon is the lack of criminal activity.
Correct.
Okay, everything else is going to be a catch-all.
It's going to be a catch-all in character.
Okay, what I would ask that you do, because I'm going back and forth, it looks like some of the ones well, like for example, the one where it says list of catch-all mitigators, number 5 lists Mr. Breeden. I'm assuming that's just a copy. Understood. What I would like to have is a clean copy of every mitigating circumstance, statutory or non-statutory, the defense is going to rely upon that you want me to put in the jury instructions.
Yes, sir.
I would ask that they be filed by end of business today, so the state's aware of it, and I'm aware of it going into the weekend. And in that pleading, you could list statutory and list the one you're relying upon, and then list non-statutory, and then basically every single thing you want me to list in the jury instructions.
Sir, Your Honor.
For the record, the state of Florida, other than I noticed they have to make a name change, no objection.
I understood. And my guess is what you're going to put in this one pleading is going to be everything you probably have in these two. I just wanted it to be, however you listen on that pleading, you're telling me that's how you want it listed on the jury instructions.
Understood.
Okay.
And that was a typo on my part.
Oh, I understand. I just want to have one pleading so it's easier that way.
And speaking of typo, Judge, I provided it to the clerk.
I'll deal with that later.
Understood.
I got you. That's a JAC issue.
Clarification of the 5 days, otherwise they won't pay it.
Understood. I'll deal with that later. I think that was everything that I wanted to talk about today. I also worked on the verdict form. The verdict form is going to be different for counts 1 or 2. Supreme Court, I think sometime over the summer, came out with new instructions on these issues. I pulled it straight from the Florida Bar website regarding the verdict form. I'm happy to share sometime today what I've created. That way you guys can take a look at it. The only thing that's going to be different between the two is, as of right now, number 6. On the aggravating factors, that won't be on one of them than the other. I think the verdict form is a lot cleaner than what it used to be, if you ask me. That's all I wanted to cover today was going through the aggravators and going through the mitigators. As soon as you give me the mitigators, I'll plug them into the jury instructions for the back end at the conclusion of the evidence, and then I'll send that out. So as soon as you get me that information, I'll have it emailed out today. My assistant's out today. If you can email it to me directly, that'd be helpful.
Understood, Your Honor.
Your Honor, on that second one that you want to circle back, are you saying let's finalize that Monday?
I prefer not. Just give me some language to work with. I'm confused.
And I'll just so our record's clear, I know we talked a lot about just to put our final position. If it's read like, and I'm tracking the aggravator from the exact statute, the defendant, the first degree murder was committed while the defendant was engaged in the commission of sexual battery, period. The state of Florida believes that tracks the exact language, simplifies it, it accomplishes any objection the defense has put on the record, and it makes sense. We would request that language. Engaged in the commission of sexual battery takes every single word directly from the statute. We're only plugging in the name of the enumerated felony, and it accomplishes overcoming any objection.
You know what? Now that I read it again, I think you're right.
Which we agree, and obviously they're going to have to make those arguments, and we can make whatever arguments.
I think he's right, and the reason why I say it is because now that I've read it about 17 times, and it says, or flight after committing or attempting to commit, that language is going towards the flight portion of the instruction, of the of the aggravator, not to the engagement. That's my fault in the way I read it. So I think the way the state just proposed it is actually accurate per statute.
The defense agrees, Judge.
Okay. So then it would read as follows: the first degree murder was committed while Johnathan Quiles was engaged in the commission of sexual battery.
Yes, Judge, we agree.
Okay.
State of Florida.
Okay. What I'm going to do is I'll work on this afternoon as well, email out clean copies to everybody of the preliminary and the verdict form. I'll send out the charging instructions for the very end once I get the defendant's pleading regarding the mitigating circumstances. Is there anything you want me to inquire about with your client, Ms. Michelle or Mr. Davis? Obviously, he's been present the entire time we're going over the jury instructions. I'm sure he has an understanding as to the aggravators and mitigators and what we're doing.
Judge, I don't think it's necessary.
And he understands what we're talking about here?
Yes, he knows. We've gone through some of this with him already, so yes.
And he's aware of all the mitigating circumstances being alleged?
Yes, so now we've gone through that. That's been some time ago that we went through that with him.
Is there any mitigating circumstances he wants you to allege that you have not alleged?
Not that I'm aware of, Judge. If you want to inquire,
Yeah.
just to make it clear.
Mr. Quiles, can you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? All right, sir, you can put your hand down. So, sir, your attorney's filed a couple different pleadings regarding mitigating circumstances that he wants me to instruct the jury on for their consideration next week. The pleadings from August 10th of this year, he's going to file a clean copy of all this with the clerk later today and send my office a copy of it. Are there any mitigating circumstances that they are not putting forward that you want your attorneys to argue to the jury? They're arguing everything that you want them to argue. You're aware of the witnesses being called next week on your behalf, I'm assuming? Are they calling all the witnesses they want you to call? Excuse me. Are they calling all the witnesses you want them to call for purposes of phase 2 next week? And by that I mean, are they calling any witnesses, all witnesses you want the jury to consider for purposes of their sentence recommendation? Who from New York?
And Judge, they have written letters and provided those to my office as well. People who were going to try to make arrangements to come, but were not able to. And so, Judge,
How are the letters being presented to the jury?
I understand that, Judge. They sent them to me voluntarily. That's not something that I elicited from them. When they found out that that was not something that, there's no Zoom, there's no, just read a letter into the court type of thing. That was kind of I think that was just hey, we want to express our support since we can't be there, that type of thing. So,
Your Honor, just so the record is clear, the defendant wants witnesses to testify in penalty phase 2. Not Spencer, the state of Florida would agree in any way whatsoever the court would accommodate that testimony of your including Zoom or any other format that he wants. The state of Florida, I know we have not called one witness on Zoom. That's the decision. The way it happened, state objection.
and Judge, based on your prior statements, we did not believe that was an option, so we did not even.
Well, I don't think it's allowed, but if the parties are agreeing to it, given the phase that we're in, and the state's not objecting to it, I'm sure arrangements can be made.
Okay, Judge. Well, then I believe we would need to list additional people. I know specifically there are several that we've talked to. We probably would need a little time, Judge, to give that list, at least by the end of the day. I could try to get that to the state. If they wanted to speak to them, we could try to make them available. That way they would have an idea of what they would say. It's not going to be anything outside of character evidence that they've probably heard already.
They may not even want to depose them. I'll leave it up to them at this point.
Your Honor, if they make them available in any way whatsoever, speak to them, even if that means Saturday, Sunday, and I don't know, panel-wise too, or a lot of weekends, last 3 or 4, so we'll make ourselves available this weekend, even if it's just a Zoom call or a phone call. In any way, in any manner, they can let us at least inquire of them, even if it's sworn or not, but we'll agree to them producing it.
And then if you have those letters too, that letter may encompass what they're talking about as well.
Have the letters and we see it and they represent to us that's what's coming, maybe we would possibly elect not to speak to them in person or on Zoom or otherwise. So yes, I'd ask them just to give us the letters, and if that's the folks that are testifying within the 4 corners of what they have in those letters, we most certainly agree to that.
That I can give them today without any issue. Otherwise, what I'll do is I'll give the letters, confirm who additional he would like for sure, and then provide their names and phone numbers to the state before the day's out. That way, if they want to speak to them personally, or if they're, if it's sufficient just from what's in the letter, then maybe that will resolve it. I don't expect it's going to be 10 more people or anything along those lines, Judge. So I just expect to be a few additional people, grandmother, maybe a cousin.
That's fine. I'll get with courthouse IT regarding getting Zoom set up for that portion of it. What I'll probably do is whenever that testimony is being heard, have it heard in a block if I can.
Yes, Judge.
Get the jury a break, get it set up, get that testimony, get the jury another break, and then we can put the stuff away, given the phase that we're at.
Judge,
I guess
thank you.
the smart word will be used, but I'll get with IT about that later this afternoon and have it set up. Obviously, however we set it up, I want the jury to see the person, and so I'll get with the staff about that later today. What Zoom ID and information it would be, I don't know the answer to that. I will get that information as soon as I can figure it out.
Yes, sir.
It may be my normal courtroom ID. That's beyond my purview, though, how that would work.
That's fine, Judge. You let us know, and we appreciate the consideration. Thank you.
Okay.
Judge, I do have one quick thing to add to that. If they are appearing by Zoom for identification, is the court going to require an ID and then show their ID to be sworn in by the clerk? And I'm just asking so that we know how to properly prepare them.
Your Honor, let the state have the opportunity to speak to them, receive letters. We may ask that they identify themselves to us this weekend, if that's the case. Ask for that.
Because typically when you have a proceeding of this, they go to a court reporter's office. They can assure who they are by a notary of some sort. Obviously, we don't have that capabilities, but if the parties are agreeing to the procedure, obviously in yours to his benefit, then I'll work with you guys on that procedure.
Just for the record, someone way smarter than me, certain technology, just advise, we have used our paralegal and other person or patient with death this year. You take your laptop and you plug it in from the card. It will zoom in and it's showing on all the screens. I think you have it on.
I'll talk to IT about that.
Yes, sir.
I would hope that they know how that works. But I appreciate that. That's a good idea that I'll mention to them. I'm not sure where the camera would be for the courtroom, so the witness can see what's going on in the courtroom. I don't know the answer to that, so it needs to work both ways.
Yes, sir. I mean, typically both devices have a camera and then whatever's being shown.
Oh, so you're saying the laptop would be the camera?
Yes, it's on the.
No, I'm saying how would the witness see what's going on in court?
You're presuming that the laptop has a camera and on their end as well.
So they essentially would be at the podium with the laptop, talking to them. Okay. Okay. I don't have a laptop that fancy.
I know in front of Judge Lester and Clay, we have a laptop that we use, and I inquired a witness. You'll and put the camera on the laptop.
So then essentially it would be, in that scenario, it would be defense counsel zooming in and that witness zooming into their Zoom, and all Miss Michelle would be doing is plugging her laptop into the device.
And when she's done, the state of Florida goes right to where she was, stands in front of the computer and talks to them.
And that way it's shown on all the all the video boards.
Yes, sir.
Do you have a laptop that has a camera?
Yes, we
Okay.
do. So that's not an issue whatsoever.
Okay.
If you want to do it that way.
What I may do is call IT and have them maybe come here early Monday. That way they can verify that procedure works. Otherwise, otherwise I may say, what's plan B just in case?
Yeah, maybe using yours as a backup, and there's a smart board there that we use in court. That would be the backup. But if that works, then we can give them the Zoom information have them set up. I can practice with them before, that way we know there's no issues on their end.
Yeah, go ahead and
Do that?
set that up on your end, and I'll get with IT and let you guys know.
Yes, Judge, we'll do that.
And so how many, Mr. Quiles, how many witnesses is that? You said 3 to 4, your grandmother and cousins? Okay, so about 3, okay. And so we'll make that happen for you. And I'm sure council will work with the state of making that sure, but we'll make sure, obviously New York's a ways away, and we'll make sure the jury hears from your family. Is there anybody else you want them to call that's not being called now that you know family from New York will be able to present to the jury?
I gave instructions to my attorney to go to my aunt. That's more of the, I've been in here so long, so I don't know contact. She has all the contact.
Oh, who to contact New York?
Yes.
Oh, okay. Outside those New York people and who your attorney is already calling, is there anybody else you want them to call? Okay.
We do have that, Judge. We have his aunt, extended family that's here, as well as the people from New York. And like I said, given the change here this morning, we'll work on that this afternoon.
Okay. So there may be more than just the New York people?
No, I think the only additional person was he suggested a couple. I will reach out today. I believe I've received letters from everybody that his aunt has already been in contact with.
Is the aunt up in New York?
No, she's here. She's been.
Oh, okay. I was confused by that.
No.
Is the aunt one of the witnesses being called?
Yes, she is.
Okay.
And she's been kind of coordinating with getting, that list to us. So I don't think it'll be any issue. Everybody that he's suggested, even today, that he's leaned over and told me, I've already had some contact with. I've already at least given their names, that type of thing. So I don't think there will be any issue with getting that information. So outside of the people he suggested to us, I don't think there's anything else. If you want to,
They need to be available Monday afternoon.
correct. And obviously, I don't know that, but I'm going to tell them today.
They need to be. That's their chance.
Correct. Obviously, I don't know as we sit here because I've not contacted anybody, and I told them that wasn't an option before. So I will let them know today, and whoever's available, then I will, of course, give that information to the state. That way they can know in advance. I will do that before the end of the day.
And you have good communication with those people up in New York? So they respond quickly?
Yeah, we've never had any issue with responses
Okay.
coming from the family. That's never been an issue whatsoever.
Because my concern was them not getting back to you in time and what that does.
No, they actually sent letters, like I said, unsolicited very quickly, so that wasn't as soon as they found out that there was this going on.
Well, whatever number it is, get with the state. I'm sure they'll work with you guys, and we'll make the IT stuff work on our end.
Yes, Judge.
And we're relatively confident that will not expand our case any more than the half day we've already said.
State, do you have any, other than, I know you said a lot of your aggravators are listed in the evidence of the guilt phase of the case. Are you calling any additional witnesses outside victim impact testimony?
Your Honor, we thought about that. We will have the lead detective here for the on our, in essence, our case sheet.
Okay, so obviously, it sounds like it would go to the defense case in chief rather quickly.
We have the 2 victim impacts, and maybe 3. I think only 2.
I guess my point is that not going to last 3 hours, so,
It most certainly will not.
okay. My goal would probably be to close Tuesday morning for you guys, just so for preparation purposes. If you guys end early on Monday, I'll go to closings, but if it's 4 o'clock, I'm not going to close. I'll bring you guys back Tuesday morning, 9 o'clock to close, and give the jury all day that way, however long they take. Is that
We've talked to the state, and I think the defense would agree that we are going to be prepared to do closings on Monday because we do not expect the information, and even in the depositions of how long each of those witnesses took, I just don't see that being an all-day affair.
how long would the doctor be?
The doctor would be the only one, and that report is not extensive by any means, just because there's not a whole lot there. And so I don't expect her to be a lengthy witness by any means. Bob?
I agree.
Okay.
That's why we're meeting.
Okay, we'll see how it shakes out. The jury knows it's, Monday, Tuesday, so I believe I told them that, or early portion of the week, so we'll see what time it is. I'm assuming the closings won't be as lengthy as the guilt phase,
No.
nor will openings at that same time.
I can tell the court now, opening with, no additional evidence other than victim impact, and talk a little bit about the aggravators. You're not talking about the opening at all. But on our 2 witnesses, at most, I think
Just remind me to read the jury instruction regarding the victim testimony before they testify as well. Okay, I'm glad we worked out the witnesses from New York, that from Mr. Quiles, and is there anything else we need to handle today?
No, Your Honor.
Sure, Your Honor.
All right, I'll share everything I've been working on, and as soon as I get the pleading from you, Mr. Davis, please make it a PDF that's been filed. Send me the filed copy. I don't want a Word document.
Yes, sir. And just to be clear, so the style of the case, statutory mitigator, non-statutory mitigator.
However you want to parse it out, I just want one pleading that has all mitigators you want me to read to the jury. If you want to parse it out as to here's the one statutory one you're alleging, and then you want everything else you're alleging under the sun, that's fine. I just want one pleading I can refer to that cleans everything up, that I can basically say this is what I'm reading to the jury at the close of the case.
Sir.
And just send me the copy that's been filed. Send me that PDF copy.
Absolutely.
Anything else from the state?
No, Your Honor.
Spence?
No, Your Honor.
Okay, well, how about we get here at let's get here at 9:15. We'll make sure IT is working, handle any issues we need to handle. That way at 10 o'clock when the jury gets here, we can move promptly.
State will be present. Yes, sir.
Sir, Your Honor.
All right, you guys have a nice weekend.
Who does want?